Hello everybody. In this video, I'm going to talk about the basics of evidence law. Evidence law is an important as well as interesting act of a nation. So learning the basics will help you go through the entire act without much difficulty. So without wasting your time, let's keep going to the video. Okay, why the act is important? Let me give you the ideas and principle that has been enunciated in the act. Okay. The first one is that anything by which any matter of fact is established or disproved. What is the principle? Means by which facts are proved. Okay. In the Evidence Act, facts plays an important role. If you are going to a court and say that this thing happened in this place, the fact has either to be proved or to be disproved. So how you will prove that or disprove the fact? So you will provide an evidence to it. It can be a paper, it can be a material, it can be anything. So that will help the court understand that the fact is either a true one or it is not true. So that thing is an evidence. Okay, it can be oral, it can be documentary, it can be anything. So this is the first idea, and it is the most important idea in the act. Okay. The second one is that evidence may be given for establishing the existence or non-existence of fact. What is the principle? Relevancy or irrelevancy. Okay. This principle will help the court to see the documents that has been provided before the court. I mean, documents and also any evidences. Okay. So the people will provide any material that can be either relevant or irrelevant. So this idea will help the court to actually save them and only check what is important or necessary to the court. Okay. The third principle is that burden of proof. Okay, who is bound to prove the fact? If I'm going to assert a fact, I have to prove it. Okay. So if I'm going to disprove it, or if my opposite party is going to say that this is not true, so he has to prove that this is not true. So this is what the burden of proof, and it will shift. Okay. So we will discuss about it in a very detailed manner in a later videos. Okay. And the fourth principle is a competence of witnesses. Okay, all persons competent to testify unless the court think otherwise. Otherwise means the factors that has been mentioned in that, like the lunacy or the age, anything. Okay, that has been already provided in the act. So this will determine the competency of the witness. Okay, this is the most important principle. And the last one is that witnesses how to be examined. What is the principle behind it? Chief cross re-examination. Actually, this is the method. Okay, this is the method of examination, and all these factors, all these ideas and principles will give you the detailed insight to the act. Okay, so I'm not going to provide the detailed instructions of this act right now, because in this video I'm going to provide only the basics. These concepts will help you understand the detailed factors. Okay. Okay. Now let's have a look at the definition. Okay. Section 3 of the Act provides the definition of the term evidence. And evidence basically means and includes statements and documents. Okay. These two things, statements and documents. So let me read the definition for you. Evidence means and includes all statements which the court permits or requires to be made before it by witnesses. In relation to matters of fact under inquiry, such statements are called oral evidence. Then all documents including electronic records produced for the inspection of the court, such documents are called documentary evidence. Okay, basically two things. All statements given by the witnesses or documents produced before the court. Documents also includes the electronic records. Okay, this is the basic idea of the evidence. So statements and documents. Okay. Then documents also have further classifications like primary and secondary documents and all. We will discuss that in later videos. Okay. So this is the structure of Evidence Act. It is divided into three parts.
The first part deals with relevancy of facts, second one on proof, and third one the production and effect of the evidence. Okay, and it has 11 chapters and 167 sections over.
So coming to the first part, the relevancy of facts. It includes the following concepts like of facts, of judgments, of opinion, of character. Actually, this part is the bigger part and it has a lot of basic concepts and you have to be thorough with it. Here, the first concept of facts. It includes topics like rest, just day, motive preparation, occurrence, mm, and explanatory, introductory facts, to evidence to prove conspiracy, and admission, judgments, etc. Okay. Then the second thing of judgments, when the judgments become relevant. Third thing of opinion, when the opinion of third persons become relevant. Third persons includes experts and the persons who has the knowledge of particular fact, etc. Then of character, when the character of the parties becomes relevant. These are all comprised in this part.
Part on proof. It has basically three concepts. Facts need not to be proved, oral and documentary, of exclusion of oral by documentary. First thing is facts need not to be proved. In certain cases, you don't have to prove the fact. The court will take judicial notice, or if there is already a law about it, in that cases you don't have to prove the fact. Okay. Then the second thing is oral and documentary. Actually, these are the modes of proof. Oral evidence. How you will produce oral evidence? By witnesses. And then there is documentary evidence. It is further classified into public documents, private documents, and all. Okay. Then third thing of exclusion of oral by documentary. In certain cases, you cannot produce the oral evidence. You already have to produce the documentary evidence. Okay, for example, if there is already a written contract, you can't say this written contract was happened in this place and all. You have to produce the written contract to the court. Okay, so in certain cases you can't produce oral evidence, you have to produce documentary. Okay, this is the um, this is comprised in the second part. And now the third part, production and effect of evidence. And it has the following concepts like burden of proof, estoppel, witnesses, examination of witnesses, of improper admission, rejection of evidence. And first thing I have already said, who is bound to prove the fact? Burden of proof. If I am going to assert the fact, I am bound to prove the fact. If someone negating the fact, he has to prove that the fact is untrue. So this is the burden of proof. Okay. Next concept, you have already heard about it, estoppel. Before court, I am going to say this thing has happened in this place. Okay. And later on, I am rejecting it. I'm prevented from rejecting it actually because the concept of estoppel comes into force. Third one, witnesses. Okay, who is competent to testify? Some people will be prevented to appear as oral evidence because of the factors like lunacy or the age. A child below 5 years old cannot come to force and give evidence. So like that. Then fourth one, examination of witnesses. As I've already said, the modes of examinations like chief examination, cross examination, re-examination. And there is also the other concepts like leading questions and here there are hearsay evidences. So this thing you have to understand it. Maybe in my later videos I will update it. Okay. Then last one of improper admission, rejection of evidence. So all these concepts will be covered in this part, and that's all about it.
Some important topics. The relevancy of facts. That is part one, which is most important thing where you have a lot of concepts. Some of them are rested state, steady parade, admission, confusion, education. Rested state is nothing but of happening things in the course of event. Like when you see a murder, the murderer buys a knife, and where he buys the knife, and how he used it, where he traveled, everything becomes a part of the event. So those all things are helpful to establish a fact. So that is Test. Okay. Test ID is identifying a thing to establish a fact, like identifying a person to establish a fact. Okay. Admission is admitting thing. Confession is confessing that you have committed a crime or something. And dying declaration, it is covered in section 32. It is also very important. Ambiguous document is when there is an error or when there is uncertainty in the document. Then presumption as to document, then burden of proof, privileged communication, accomplice. Accomplice is a person who has come, who will be the part of the crime and then becomes a witness to the court, saying that he is the part of the crime. Okay, he is accomplice. An examination of witness, then leading question. Leading questions are those questions that will be asked in the cross examination, and the answer to it will be either yes or no. Okay, those are the leading questions. Then hostile witness. Hostile witness are the witness who turned against uh, their own party. Okay, the party who's producing the witness, but the witness will turn against them. They are called hostile witnesses. Then the fresh in memory. These are all most important concepts. Here I will suggest the books for reference. Direct is must, you have to go through it. Second one, Avadar Singh's Principle of Law of Evidence. It's very helpful and this book explains the concepts very clearly. So please go through it.
So this is the end of the lecture. Thank you for watching and please subscribe and support.